order to give our presenters the full amount of time, I'm going to hand it over to them, let them introduce themselves, and get started on their workshop. All right, Amber and Jason, welcome to Stormwater Awareness Week, and thank you for presenting.
Hi, I'm Amber Baldrow. I'm with WGR Southwest. We're located in California primarily, but we're also in northern North Carolina. I've been a environmental consultant for about 10 years now, specializing in stormwater, but also, dabbling in other things. I have with me Jason Caruso. Jason.
Thanks, Amber. So my name is Jason Caruso. I'm an attorney and a partner at Newmeyer Dillian. We're located in Newport Beach in California, and with offices in Walnut Creek and also in Las Vegas, Nevada. I'm a partner in our land use and environmental department, and have a lot of experience, fortunately or unfortunately, with Clean Water Act litigation. And we primarily represent industry, either business owners or developers relating to these issues. And so that's the experience I bring to this.
Yeah. And so today we're going to be talking about Clean Water Act litigation and the industrial general permit. Obviously, my forte is the permit part, and Jason's is Clean Water Act litigation. But just a little introduction into today. So, of the many regulatory requirements and permits that industrial facilities are required to comply with, the California industrial and construction general permits are special in that they facilitate immediate and extensive compilation of information via smarts. Instead of having to prepare a Freedom of Information Act FOIA request and submit it to a government agency, having to wait for the request to be filled, Smarts provides a user-friendly approach to gathering information that is easy for almost any individual to use. Now, there are pros and cons to this. The pros include the public's ability to freely access this information, work with their local government to enact real change, and take action to protect their local waterways. The cons are a bit more complicated. As we'll discuss here, Smarts provides a glimpse into the facility's overall compliance, but does not provide the whole picture. Although Smarts is a useful tool, it is impossible to understand the complexity of a facility's stormwater management without more information than what is being provided to Smarts.
So just a quick disclaimer to get out of the way. Something that we're required as attorneys to put out there in kind of the first instance is that our discussion today is based on our experience, both mine and Amber's. And again, as I mentioned before, we come to this with a particular perspective and set of experiences. We strive to be balanced in all of that, but again, our kind of views about all of this are going to be based on that experience, our perspective, and what we've seen in the past. Every case is different, every facility is different, and every situation is going to be highly dependent on the facts. And so there's no guarantees about how things may go. Even the smallest change can kind of change how all of this affects you and your clients. And it's just something important to keep in mind. And for your particular situation, if you're faced with either a Clean Water Act claim or any kind of related challenge, Amber and I would be happy to discuss that really with any of you and to consult with you about that. So just to give you all some background on kind of the legal framework that we're dealing with here, the kind of core legal framework at issue here is the Federal Clean Water Act, which you can take a look at if you're so inclined as part of the United States Code at the number that's listed here on the slide. The general background here is that the Clean Water Act was enacted in the 1970s with the purpose of eliminating pollution in the so-called waters of the United States, which is a particular term of art. And if you follow Supreme Court practice, that particular definition was actually recently addressed by the Supreme Court in a case called Sackett versus the Environmental Protection Agency, addressing what the waters of the United States really means. And it was kind of a watershed change in that definition, and not something that we're going to be getting into today. That's a bit, esoterica. But the Clean Water Act in general uh, provided the Environmental Protection Agency the authority to regulate discharges into the waters of the United States and to regulate in this entire area of water quality. So our focus today is going to be the component of the Clean Water Act that made it unlawful to discharge any pollutant from a so-called point source, whether that's a particular site or a facility, into the navigable waters of the United States unless a permit is first obtained. And the system that was put in place by the Clean Water Act, we refer to as the NPDES, the National Pollutant Discharge Elimination System. And the way that that's administered, Amber touched on this a little bit, in California in particular, is via our state and regional water boards. So again, just kind of we're talking in generalities here, but the way that this process works is that covered facilities must determine whether they're subject to coverage and need to come under either a site-specific permit or the so-called general permits that regulate these discharges. And that analysis is based on the SIC code or the particular operations that either you or your client's facility are actually engaged in. And there's a whole series of requirements. The general permit is complex. If you're familiar with it, it's lengthy. There's a lot to it. And something that is important to keep in mind when it comes to Clean Water Act practice, stormwater management practices, is it can be exceptionally unintuitive. The concepts of what's covered by these permits, what needs to be covered, is not something that immediately leaps off the page, and it's a matter of experience and sometimes very complicated analysis that you want to make sure that you are on all fours about, so that you're not surprised by the kinds of claims that we're going to be talking about today. So the Clean Water Act permits what are they're called citizen suits. And these are suits initiated by private parties and organizations claiming that a particular facility or a particular site has engaged in either unpermitted discharges or otherwise has perpetrated some kind of paperwork or regulatory deficiency relating to the SMART system that Amber mentioned before. If you have any experience with, state or federal litigation, the concept of the citizen suit may actually be a little strange to you. And the Clean Water Act is unique in the sense that rather than suing someone for particular damages, the Clean Water Act basically opens this up to basically anyone that's affected by a claimed discharge from a facility or impacts to waterways, to essentially give folks an incentive to enforce these claims, to not leave it up to the government, but it enables private parties and organizations to pursue these claims in their own right. The incentive being the recovery of attorney's fees from the offending facility. And so your client's first notice that they may be involved in a Clean Water Act suit may be this so-called 60-day notice, usually a lengthy document that they'll receive in the mail or otherwise will be sent to them, that will detail the purported violations that the claimant in that case is alleging exist. And those can come into a series of categories, different kinds of issues relating to discharges. And the first is just the classic unpermitted discharge, a discharge of a pollutant from a facility associated with their industrial operations. The other kinds of issues can be the failure to implement sufficient mechanisms or practices to minimize potential discharges from a facility. And the other kinds of violations include, the so-called paperwork issues. And that can be the failure to adopt an adequate stormwater pollution and prevention plan, or an insufficient monitoring implementation plan, or to otherwise improperly report measurements via that SMART system, or to otherwise, not properly report or respond to notifications or issues that you've received from your regional water board. So the idea of these notices is to literally provide you or your client notice of what the issue is, to give yourself an opportunity to investigate the issue, determine if there's actually a problem, and figure out what the proper response might be. And with that, I think we can go to the next slide. So something important to keep in mind, and again, is not something that's going to be intuitive for you or your client if you receive one of these notices, is to determine who is suing you, who is making the claim against you, and asserting the particular violation. Interestingly enough, this information is generally publicly available. There's a lot of tracking of and basically databasing of who issues these notices, what law firms they're associated with, and if there have been any settlements relating to these issues. All of this information is public. And if you're familiar with Proposition 65 lawsuits in California and the associated notices, the regime is very, very similar, and the process is very, very similar. In my experience, generally, there are two broad categories of folks that are asserting these Clean Water Act claims. And the first are environmental organizations, and folks that our office has dealt with in the past have included the Center for Biological Diversity. There's LA Waterkeeper, there's San Francisco Baykeeper, and various similar organizations that have as part of their mission essentially policing water quality issues. And the dynamics when you're dealing with an organization like that versus a private party can be significant. The kind of the interests and a lot of the dynamics as far as how these cases can be resolved can potentially be very different when you're dealing with an organization that's kind of mission driven relating to these issues versus a represented individual who may be asserting this claim, and this may be the only time that they're asserting that claim. And so that's why it's important in Amber and I's estimation to make sure that you are working with folks who are experienced with these particular organizations and with these claims, to make sure that you're being properly kind of advised and navigated through these issues. Something you'll notice when you deal with these, when you see these claims, is they are often a lot of the same attorneys and a lot of the same law firms that are dealing with these issues kind of over and over and over. There are firms that where they have a focused practice on these particular issues. And it's not a one size fits all approach. It's going to be very case specific, dependent on your particular situation, what exactly you're faced with. Your geographic area is also going to matter significantly. And then the particular people that you're going to be engaging with on the other side can really change the dynamics. So when you receive one of these notices, obviously not something to be ignored. There's a strategy in some cases, these kind of citizen suit type cases, to throw the notice away, ignore it, put your head down, see if it's just going to disappear. And I can't stress enough, that is not the approach to take. In these cases, you are being pursued by and large because there is a documented issue via the SMART system, or there is a very obvious issue that either an organization or a represented person has come across. And so these are by and large, these are not like completely unfounded claims. Somebody thinks that they've seen something that's problematic. And again, going back to the kind of the citizen suit mechanism, there is an incentive for these folks to pursue these claims. And so they're not something that they're generally just going to go away on their own if they're ignored. The 60-day period provided by these notices, it's to give a grace period before litigation is initiated, to give the recipient time to look into what the claims are, to actually investigate them, figure out if there is a problem. And for the unfortunate folks who get the notice and say, well, what the heck is this? It gives you time to engage the appropriate professional and ask folks, whether there is something to the claims and whether there's something that, you or your client should have been doing already, that you need to get caught up on. It's even when you ask for help relating to these claims, we strongly suggest reaching out to someone that has dealt with these types of claims specifically. General practitioners, either, environmental professionals or attorneys, folks that are generally experienced in those areas, they can be fine in a pinch, and frankly, in some instances, may be able to navigate the claim successfully. But, we have seen scenarios, unfortunately, where folks simply don't know what they have, or, may overestimate or frankly underestimate the gravity of the problem, and be unable to give kind of that case specific, experience driven advice regarding how to navigate those claims. So as far as kind of your initial outreach, if you get one of these notices, if you have a consultant, I'm going to want to speak to that person, to get a sense for what's going on, why certain things have been happening, what's the background of the situation. And if you or your client don't have a stormwater professional, or it's completely new to you, that there are any requirements in this area, well, my first order of business is going to be to get you connected to somebody like Amber, who has experience with these issues, to help us get our hands around the situation from a technical perspective. And if you need a stormwater program, to get that going. And then always importantly, it's going to be important for us to get boots on the ground, take a look at your site, get a sense for what's going on, and to help you navigate the claims process. So there's a particular life cycle to these Clean Water Act claims. Um, occasionally, the matter can sometimes be resolved during the 60-day period once the notice is issued. And there may or may not be, depending on your situation again, there may be advantages and sometimes even disadvantages, but it all depends on your particular situation to see if the matter can be resolved in that initial period. We've had success in engaging with issuers of these 60-day notices to talk to them and basically engage them at the beginning, at the threshold, to say, listen, this notice is misdirected. The facts are just not, that you don't have all the facts here. Here's the explanation about what's going on. And we've had success in getting folks to desist from proceeding with their claim based on kind of early action. So again, this all militates in favor of getting on these issues at the outset and giving us the time and the runway to deal with these issues. If the matter can't be initially resolved, can't be resolved right then, what generally happens is the matter then proceeds to litigation. These cases are, with very minor exception, they're usually litigated in federal court. And so the notice will then be translated into a federal complaint, which sometimes is the first engagement I have with the case in situations where clients have not kind of heeded the advice of getting us involved immediately. They say, oh, shoot, we ignored this notice. Here's our complaint. Can you help us with this? Which is ideally not when I get involved. Ideally, we're getting involved earlier than that to see if they're, to take advantage of that notice period and to see what we can figure out. But if we proceed to litigation, either because the matter can't be resolved initially or because folks didn't get on the issue immediately, it's not the end of the world. That's just fine. I'll kind of gloss over the kind of the full life cycle of these cases, because I could talk about this for a very, very long time. But to kind of jump forward, and this is true of the vast majority of civil cases, of which these Clean Water Act cases are one, the vast majority of these cases resolve. And there are various ways to resolve these cases. And kind of the primary mode is listed here on the slide. The first is the so-called federal consent decree, which is basically a negotiated court order that requires certain things, and most often it's compliance with the permit, fixing certain issues at the site, ensuring that there is future compliance. Very often there's a monetary component, which itself can be composed of various pieces, but primarily is essentially a penalty payment and an attorney fee provision. Basically, rewarding the folks who pursued these claims with reimbursement of their attorney's fees. Though these consent decrees, need to be carefully negotiated, because what they result in is generally passive, if they're successful, oversight by a federal court for a period of years to make sure that the facility is doing what they're supposed to be doing. The benefit of these consent decrees can be certainty, to make sure that during this period that you will very likely not be pursued for further issues during the pendency of the consent decree, because very often other claimants will see that a consent decree is pending and then not bother you or your client for at least the pendency of that decree. And then hopefully, if the consent decree is fully complied with, then going forward, there is much less of a chance for future issues. Kind of in contrast, and again, there can be benefits to this depending on your situation. Agreements can be struck, basically private settlement agreements to resolve these cases. These basically take the form of a contract, usually, that is not reduced to a consent decree, not enforced in court, at least directly, and does not result in kind of continuing jurisdiction with the court in most cases. And the drawback that can be associated with these kinds of agreements is the fact that there is not kind of that judicial supervision, because it may not operate to fend off other lawsuits. But again, there may be advantages to this depending on your situation. In particularly in situations where you're not looking for some of the benefits that a consent decree may provide.
All right. Thank you, Jason, for that amazing breakdown of that process. So Jason had mentioned the water quality standards, one of the reasons why some of these 60-day notices are issued. So I'm going to backtrack a little bit into that, talk about the compliance side of this whole process, why we're essentially here. So the Federal Clean Water Act defines water quality standards or water quality objectives to include both designated uses, i.e. beneficial uses, and water quality criteria, so water quality objectives. The basin plans that the regional water boards and the state water boards create, along with the Office of Administrative Law, are approved by the US EPA and contain water quality standards for those regional water bodies. Now, the basin plans are used as regulatory tools by the regional water boards where those standards, those prohibitions, and other programs of implementation applicable to a particular discharge or category of discharge, that means the industry or the sector that industries may be in, are then incorporated into specific orders and permits. These basin plans are available online for anyone to see. They list beneficial uses of WOTUS, waters of the United States, within each region, as well as water quality objectives. So these objectives can be both numeric, meaning solid limits, numeric effluent limitations, and they can be narrative. Typically, these water quality control plans and their associated state policies are scheduled to be reviewed every 3 years. They're actually under review right now. So some of the beneficial uses, just so that you get the idea of why people would care, why the numbers off your stormwater site are maybe elevated. Beneficial uses of these waters include municipal and domestic supply, agricultural supply, industrial supply. Industrial facilities use water, groundwater recharge, freshwater replenishment, navigation, hydropower generation, water recreation. I know maybe in Southern California and some of our water bodies, not much water recreation, but the idea is there. Commercial and sport fishing, aquaculture, freshwater habitats, and both warm and cold, and saline water, estuarine, marine, and wildlife habitats. So each regional basin plan, there's 9 regions in California: North Coast, San Francisco, Central Coast, Los Angeles, Central Valley, Lahontan, Colorado, Santa Ana, and San Diego. They have their basin plans, and that's what they use to figure out how they should apply these water quality objectives to specific permits that apply to industrial users. Something that's controversial in its application to facilities or industrial dischargers. What really shouldn't be is that the California Toxics Rule, the water quality objectives, and the basin plans, they're applicable to the water bodies. The state water board and the regional water boards use these to incorporate these requirements into the permit. So whether that's the industrial general permit, the construction permit, individual site-specific permits for larger dischargers, effluent limitations in those permits are set on an industry by industry basis based on categorical determinations. They've been reviewed and assessed and monitored for decades. There are many levels of control from numeric limitations to benchmarks to BAT, BCT, BPT, BMPs, all the acronyms. All of these based on each industrial category or subcategory practices. Now, I won't go into each of those. I feel like that would be too much, but BAT is the best available control technology economically available. BCT is the best conventional pollutant control technology. BPT is the best practicable control technology currently available. Effluent limitations mean any restriction established by a state or the administrator on quantities, rates, concentrations of chemical, physical, biological, and other constituents which are discharged from point sources into navigable waters. The water is the contiguous zone or the ocean, including their schedules of compliance. The EPA defines point source pollution as any single identifiable source of pollution from which pollutants are discharged, such as a pipe, ditch, ship, or factory smokestack. The Clean Water Act defines point source, meaning any discernible, confined, and discrete conveyance, including but not limited to any pipe, ditch, channel, tunnel, conduit, well, discrete fissure, container, rolling stock, concentrated animal feeding operation, or vessel or other floating craft from which pollutants are or may be discharged, meaning it must be a separate from other discharge, i.e. discernible. Otherwise, it's not identifiable and effluent limitations are not enforceable. All that to say, water quality objectives are intended for the receiving waters. The 60-day notices and things that I've seen, they do list water quality objectives as limits being applied to specific facilities, when in reality they have limits of their own in their permits. And these water quality objectives are guidelines essentially used by the state. I mentioned site-specific individual NPS permits, so that's separate from the industrial general permit that we're focusing on today. But those permits are for 40 CFR Code of Federal Regulation effluent limit guideline facilities. They're large point source discharge facilities, large operations. So due to their waste discharge commingled with stormwater, those facilities have effluent limit guidelines in their permit, and that permit is specific to their operation. Whereas the general permit, it has primarily BMP-based BAT, BCT for light industrial stormwater, though receiving water-based total maximum daily loads have since been added in 2020, establishing those numeric effluent limits that many of you may be discovering or becoming acquainted with. General permits are generally low risk, multi-sector permits, so benchmarks generally make the most sense. Individual NPS permits are moderate to high risk facility specific permits, so those effluent limits applied after careful consideration by the water board. The water board is responsible for implementing and enforcing these limits. So these litigations are in addition to that. Another factor compliance-based that I've been experiencing involved in these litigations is sampling parameter determinations. So the most common issue are adding extraneous parameters that are improperly assessed. IGP section 11.B.6 requires certain parameters be sampled by all general permit dischargers. So as everyone knows, total suspended solids, oil and grease, pH are minor basic requirement. In addition to that, any SIC code or standard industrial classification code requirements must also be sampled. In addition to that, the receiving water assessments, and that's where I've seen misinterpretations of the permit requirements and leading to issues. So, for example, if a facility discharges to receiving water impaired with iron, the facility must assess all exposed industrial activities for the presence of iron. And if it's present, then it must include it in its sampling as applicable. The SWIP must detail this assessment, narratively explain whether receiving water impairment is applicable or not applicable. Typically, I include these as detailed tables that list all potential parameters applicable to the facility, go through them one by one, and ensure that no stone is left unturned. All assessments are done. Now, if the facility assesses for iron and it's not associated with industrial activity and samples it regardless because they misinterpreted the permit requirements and thought that any receiving water impairment was required regardless of presence or association with industrial activity, the facility may find, very well likely, that stormwater discharge contains some level of iron, likely or potentially from various non-industrial sources. Iron is a common background source seen in stormwater discharges. So regardless of how that parameter, iron or any other parameter, was added to the facility's stormwater samples, an exceedance of an NAL, there aren't any NALs currently for iron to my knowledge, but an NAL will prompt those exceedance response actions, and the facility will be required to continue to sample for that parameter until all the permit requirements are met. And likely even after that, it is quite difficult to remove parameters, even if they have no association with your industrial activity. It requires a close consideration and communication with the water board. They essentially have to sign off on that. So each sample parameter, whether actually required or extraneously added, requires analytical costs, ongoing assessments, tracking, and reporting. In the case of parameters exceeding numeric action levels or numeric effluent limits in the general permit, the facility must contract WISPs, experienced professionals to evaluate the site, prepare necessary reports. Existing BMPs must be reevaluated and improved. Monitoring by trained and knowledgeable persons should reflect these efforts. It's a whole process. It all potentially started by not understanding the requirements of the permit, and adding extraneous parameters. Now, I want to put a caution. That isn't to say any parameter could be an extraneous parameter. It is really a careful consideration and understanding of the permit, what would be considered an extraneous parameter. So, which is why whenever I'm contracted by a facility, particularly when a facility is a new discharger, maybe they just started operations, they need what's called a new discharger statement prepared in accordance with the permit. It really is a good opportunity for me to be involved and sort of explain all of those requirements and provide them a thorough sample parameter determination and ensure that they have a strong foundation to follow and hopefully stay in compliance with. With that said, the permit allows facilities to perform non-industrial pollutant source demonstrations to prove that a pollutant is contributed either solely or predominantly by non-industrial sources. However, this demonstration must be conducted by an experienced WISP, ensuring the resulting report is both methodical and thorough. The non-industrial pollutant source demonstrations commonly include source assessments and upgradient sampling and any effort to identify where that exceedance of that pollutant could be coming from, roof, nearby fences where runoff is occurring, even industrial activity on site. And may include sample controls and blanks in order to compile and prepare a thorough both level 2 ERA action plan and a level 2 ERA technical report. It is up to the facility to assess their own stormwater discharges, preferably with the assistance of someone with a thorough knowledge of the permit. A thorough pollutant source assessment by a competent person should include a facility's industrial materials, whether those materials have the potential to contact stormwater or surfaces exposed to stormwater, meaning they're outdoors. An evaluation of existing control measures as they pertain to these sources, and which pollutants must be sampled based on permit requirements and facility industrial activities. I think I talk about it a bit later, but it's also important to remember that whether a facility is required to sample for a parameter or not, if that parameter has a numeric effluent limit, as I mentioned earlier, the permit implemented total maximum daily loads into attachment E in July 1st, 2020. Exceedances of those numeric effluent limits are violations of the permit and warrant the water board to issue mandatory minimum penalties. So for all of those reasons, it is vital to have a whole SWIP and monitoring implementation plan prepared by a knowledgeable person to set the facility on the right path. Another issue, compliance-wise, that I've seen in these litigations and otherwise are qualifying storm events. Particularly in Southern California. I'm sure some of you are watching from Northern California, but in Southern California, we don't get that much rain. Maybe recently we do, but not historically. So whether a qualifying storm event occurs at a facility is dependent on so many factors. The permit itself has requirements on what warrants a qualifying storm event. There's time limits, operational hours have to be considered, sampling timeframes have to be considered, whether one discharge point starts before another one, and the time starts for the first discharge point, and then you could miss the second one. There's just so much minutia involved. Both the water board and any interested third parties, for litigation purposes, use nearby weather gauge stations to track precipitation in the region. So these weather gauge stations, you can see them at weather.gov. It's how I track weather for the area. And anytime we see forecasted rain, we make sure our clients are prepared for sampling or just the rain to hit. But you can see these rain gauges on weather.gov, and they're managed by NOAA, and they can be located many miles from your facility. For example, if your facility is in a specific part of Compton and the nearest weather gauge is at LAX, and LAX registers an inch of rain, it doesn't necessarily mean that an inch of rain fell on your facility, but that is difficult to prove without more data or barring additional data such as an on-site rain gauge documentation, right? So your facility has a team of pollutant prevention team members, and hopefully they are tracking the rain and being aware of when forecasted rainfall may occur. And when it does, even if it's a small sprinkle of rain wets the facility, doesn't actually cause a discharge, it's highly recommended to document that if you don't have an on-site rain gauge available. Electronic rain gauges are options. They provide exact start and stop of rainfall. They're not required by the permit, but they are greatly informational and handy in cases where you are in an area where there's not much rain and you sometimes need to prove that it didn't touch your facility during that specific event. It's important to have these conversations, understanding your site's flow patterns and permeability and where discharge occurs and whether that discharge is industrial or non-industrial, with an experienced consultant. Your goal is to collect representative samples of industrial stormwater discharge, and with the majority of these samples being grab samples, it does require a thorough understanding of both the permit and your site. So moving into the next section, we title this slide "Stack the Odds in Your Favor," because as mentioned before, SMARTS can provide a glimpse into a facility's overall compliance, but it doesn't necessarily provide the whole picture. SMARTS includes a facility's notice of intent, annual and any correctional reports, exceedance response actions, water quality-based corrective action reports, your SWIP, your site maps, and of utmost interest, your sampling data. So in reality, with these 60-day notices or just any interest in an industrial facility, the idea is if the facility is not meeting numeric action levels or effluent limits, there's assumed to be an inadequacy with the stormwater program. These NALs and NELs are triggers to alert the facility of the need to reassess the program, make improvements, bring those levels down to at least background levels. This includes ensuring the SWIP is adequately addressing the facility activities, BMPs are adequately addressing the associated pollutants with those activities, ensuring all required submissions are completely, properly, and within required deadlines submitted and certified in SMARTS. Missed deadlines are, to someone looking outside in, an indication that maybe this facility's program is not being managed properly. So work with your consultants that have experience in the permit, in litigation such as this. A fresh perspective from an experienced person is vital in reassessing a program. And at the end of the day, a facility's permit compliance and how they appear on SMARTS is the facility's responsibility. I'll show some screenshots from SMARTS in a second, but as many of you know, SMARTS performs some services such as tracking numeric action level exceedances, but it's been made very clear the Water Board makes no guarantee of the accuracy of such tracking. It is on the facility to properly track its own compliance and respond accordingly. And in addition, since implementation of those numeric effluent limits, SMARTS does not track those exceedances. Those are wholly required to be tracked by the facility, and upon knowledge of exceedance, initiate that water quality-based corrective action report. So, SMARTS. Since Senate Bill 205, SB 205, passed in 2019, more industrial facilities are learning they are required to obtain IGB coverage, which is great. Each city implements SB 205 a little differently, but when facilities apply or reapply for their business license, they are prompted either to provide their NPDES permit information or confirm that no NPS permit applies to their facility. There are different types of coverage. I don't want to go too much into the super basics of the permit, but having certainty in whether the permit applies to you and how it applies to you is another way to prevent such litigation against the facility, whether that's notice of intent, which is just the general regular coverage, the no exposure certification, those facilities that they don't have requirements to do many of the aspects of it. They don't have exposure, or a notice of non-applicability. They don't discharge to waters in the United States. Always have your SWIP and MIP submitted on time. Any improper data reporting, ensure that the data is managed by someone who's knowledgeable on it. Data mismanagement is a common issue. And Data tracking, proper data tracking means little if incorrect sampling parameters were chosen, incorrect analytical methods requested, units are improper, anything like that. And also, late ad hoc report submissions can come with substantial fines since they implemented those mandatory minimum penalties. It is vital to get all of those in line, under control. Metal manufacturing and fabrication facilities, those are unfortunately of most interest in my experience, and searchable in Smarts, obviously. This is just the Smarts homepage, just so that you guys can see there are public accessible portions of this. They allow the user to search any which way, information for each facility, facilities in a region, outstanding reports, all the stormwater data, like I mentioned. I'm realizing the time now, so I want to sort of do it. And let's see, yeah, I feel like I got through most of that. So BMPs, as simple as they are the best defense against, compliance issues at a site, properly implemented, properly selected, and properly designed. Self-reporting, the EPA audit or self-disclosure policy, you won't necessarily get in trouble for self-reporting issues at your site, or at least you'll get in less trouble. But make sure that whatever you're submitting to Smarts is required, and not submitting unnecessary things on there. Like I said, it is publicly accessible. And for exceeding NALs and NELs, unnecessary advancement into level 1 or level 2, the most common ones that I see are honestly just improper sampling. It is very easy to have this program developed, even a very well program, and having untrained people collect samples, or otherwise not understand the purpose of why they're out there in the rain. Obviously, it's not the most fun thing to do. So those samples are representative of that industrial discharge, and it is vital that they reflect all the efforts on site. All right. Sorry, Jason. I honestly lost track of time there.
No problem. So I'll quickly go through this. So get help, is the bottom line here, and get help early if you possibly can. It's my preference, to that my clients kind of assess these issues ahead of time, and frankly determine whether they have coverage or not, and invest some of the time and resources into making that determination, rather than engaging us once it's become a 60-day notice, once it's become an actual lawsuit. An ounce of prevention is worth a pound of cure, and your resources can be so much more efficiently directed to that. And it also satisfies, what everyone is interested in, which is ensuring that there is not, that the waters of the United States, in general, are not polluted to the extent that they possibly can be, and that whatever is being discharged, that's all within the parameters of the permitting process and all of the applicable regulations. We can go to the next slide. So unfortunately, in my experience, not all consultants are created equal, unfortunately. And I believe it's important, to kind of know what you're getting when you're hiring a consultant, looking into their experience, and really gauging for yourself whether you're getting what you're paying for, essentially. Something that I think is also important is for facilities to be realistic about what they can rely on their consultant to do. The consultant in many ways can lead you to water, but can't force you to drink. If you're not implementing requirements internally, if you're not following what you're supposed to be doing, there's only so much the consultant can do. They're not there day to day. It can be difficult for them to police the facility. And so, it's very important for there to be some internal discipline and structure about that. From time to time, and I recommend, every couple of years, it may just make sense to reach out to an independent consultant, even if you've been working with one for a couple of years, and having them take a look at your program. Fresh eyes, can very often catch issues, things that you are not doing, or frankly, catching issues like sampling for parameters that you don't need to be. And both of those can potentially be significant issues, particularly if there is future litigation. So, I think it's important for both facilities and consultants not to get too kind of comfortable, right? And to occasionally just reevaluate the relationship and what you've been hired to do.
And that's awesome.
Yeah. So with that, I think it covers it.
Yeah. I'm seeing a question here. Rebecca, I know I asked for you to read it, but I actually just went on there. It's Gerald asking, who does the burden of proof sit with as to what the exact precipitation at a site was, such as when and the amount? The burden of proof is on the facility. The facility, can have an on-site rain gauge. They can just have documentation. But I definitely don't recommend not doing either. Whether it's just a simple sheet of paper. I've had a client have a sheet of paper that says storms, and every day that there's, any bit of precipitation, whether it wets the ground and stops, or it sort of sprinkles on and off throughout the day, they just keep a simple log that narratively describes what happened that day on their site. And those can definitely come in handy.
In litigation, the burden of proof would theoretically be on the claimant relating to whether there was a violation, the qualifying storm event that couldn't have been sampled. But the practical reality is, from a claimant's perspective, if a storm has been noted at the nearest weather station, their assumption is, well, you don't have sampling. And so if you as the facility don't have evidence that there was no QSE that day, or you don't have sufficient record keeping in general, there can be this data gap. And so Amber's correct that it's ultimately the facility's burden to disprove from a practical perspective. I see the next question. Are these 60-day notices and lawsuits as common for construction sites as they are for industrial facilities? So in my experience, the vast majority of the claims are associated with facilities under the industrial general permit. And I think some of the reasons for this are just that facilities are there, they're on smarts or not, and there can be this kind of body of data associated with that. And so that's been my experience, that violations of the IGP are more common than construction permits, but I have seen lawsuits and claims associated with construction sites as well. And the penalties can be severe, even in those kinds of claims.
Fantastic. Well, thank you, Jason. Thank you, Amber. We're just about out of time, so I'm going to wrap this up. But fantastic presentation. If anyone wants to get in touch with Jason or Amber, their information is on the screen, so feel free to take a screenshot or take a picture. and email them any questions. If you missed any portion of this workshop, it was recorded. It will be up on our website probably sometime tomorrow, so you'll be able to watch that. And it'll stay up on our website indefinitely, so you have free access to come back and reference this if you need it or if you want to share it. So thank you everyone for joining us, and thank you Amber and Jason for presenting.
Thank you. Thanks everyone.